Time code smart one, and then admit Jasper Williams, and then read out the heading. That's all you have to do. Ready? Okay, we're about to start now. The court associate's going to read out the heading, and then you can start.
Where's the judge?
I'm admitting her now. I'm just letting you know.
Friday, the 5th day of February 2021, Commercial Court 2 at 10:38 a.m. before Honorable Justice Williams, Civil Jurisdiction 2020, number 402 and 390. The Commissioner of Police versus Public Service Commission, Ms. Green for the plaintiff, Mr. Taylor and Mr. Horseman for the defendant.
Yes, finally, good morning to everyone. Let me just see who's on the call. Just give me a moment. Perhaps I can have Mr. Taylor give the introductions, but let me firstly apologize for the incredible delay in starting. I can assure you it was beyond my control. I suppose the only comment left to make is that we are still adjusting to having multiple Zoom hearings by different courts at the same time.
Well, Milady, thanks for that. No need to apologize. These things happen. Milady, if I may, based upon who I see, as you know, I appear for the applicant, the Commissioner of Police. My learned friend, Ms. Greening, appears for Mr. Pereira, who's an interested party. My learned friend, Mr. Horseman, appears for the respondent, Public Service Commission. Milady, you will see that Mr. Mybry, who is here, needs no introduction, is here obviously from the Attorney General's chambers.
Yes.
Milady, this is the Commissioner of Police's application to judicially review the decision of the Public Service Commission of the 17th of August, 2020. Milady, if I may, before I begin my submissions, can I just address some housekeeping to ensure
Mr.
that you have the material that we think you ought to have and help you have?
Taylor, you're freezing on my screen. I don't know if it appears that way to anyone else's screen. Okay. All right, let's try it again. I did hear your introductions, thank you. And I would just comment that this is a consolidated action. This is also the application for judicial review by the interested party, Oswin Pereira. So we're hearing these matters together.
Yes, Milady, that's right. Last time we were before Milady, that was the fact that these were to move along together was, I think, was agreed by us all.
Yes.
Milady, as I say, if obviously, I hope I don't have any technological difficulties, but if you do have trouble, please let me know, and if it's on my end, we can see what we might be able to do to remedy the situation.
Yes.
So Milady, can I just ensure that you have the material for you to in my submissions?
I think you froze again, Mr. Taylor, but I'll tell you, I understood your question. So I have from you a letter of correspondence that refers to my need to refer to your 30th of November 2020 submissions and the first affidavit of the Police Commissioner Corbishley.
Yes, milady, that's correct.
I've also kept close to me you've also filed a submission in reply to the skeleton argument from the Public Service Commission.
That's correct, milady, yes.
And being
And then-
brought now, sorry, thank you very much. I did cause a message to be sent to you that I needed a copy of the decision of the misconduct proceedings panel, which I do have in front of me. I understand that you filed it because that was evident to me in your correspondence, but it just simply was not in front of me. I do
I
have to
understand.
know.
I understand. I'm glad. That's helpful. That's helpful.
And you've filed various authorities in 3 different binders. I have them marked. One was, I think, for the purpose of the stay application. And the other appears to be for the purpose of these proceedings or this hearing. But you do have 3 binders filed before me that are marked authorities.
Yes, I think that works. And milady, it sounds to me like you have the material that that we have lodged, and I'll do my best to direct you accordingly as I move through.
Yes. In fact, correction, 4 binders, 4 separate binders.
Lady, perhaps what I can do just at the outset is, and of course, happy to answer my lady's queries as we go forward, just provide a roadmap of where how I intend to proceed so that you're aware of how I intend to advance the argument. So
Yes.
what I intend to do is take you, we started this, my lady, last time, but I tend to take you through the law that we say you ought to have in your contemplation as you consider the application. Then I will be taking you through what we say are the important aspects of the decision of the Public Services Commission, my lady. And then I think we'll do, subject to your leave, is I will have, I suspect, some reply submissions to what my learned friends have to say. But in order to try and compartmentalize it, hopefully to make it as easy for the court as possible, I'll wait until I hear those submissions before sort of anticipating them, which hopefully will move things along.
Mr. Taylor, before you do get started, are you by any chance dependent on a Wi-Fi connection? Because it seems that the service from your location is not optimal. I can make out what you're saying just by deduction if you get cut off a few words from a sentence, but maybe if you can adjust your device, that might help. I don't know.
Lady, I am on a Wi-Fi connection.
You've completely frozen.
Yeah, I've lost him as well there, my lady, so it is on his end.
Technology is unkind this morning, I have to say.
My lady, can you hear me now?
Yes, I do not see you, but I can hear you.
My lady, I wonder whether if I disconnect my video,
Okay.
it might be easier. We might be using less bandwidth. I'd be honest with you, I've done a number of Zoom hearings. It's not clear to me why this is happening, but clearly it is. When I have the video off, is the audio
The audio
more
is
stable?
much better, I have to say.
So my lady, with your leave, I will I've been told many times I have a face for radio, so we'll test it out. With your leave, I just propose to make submissions
Yes.
via audio, and hopefully this works. And I do apologize. I'm not sure precisely what's happening. So
Oh, I'm quite
Lydia,
sympathetic.
so you have my roadmap, my lady. Could I begin asking?
Mr. Taylor, I'm actually not sure that is much better. You seem, and I look to be getting some affirmation from Mr. Horseman and Ms. Greening. I don't know what they hear, but you don't sound as if you are having good audio either.
Lady, can I ask that we stand it down for a few minutes to see if there's something I can do to address the situation?
Yes.
I do apologize. I'm not sure what's not sure what's happening, but we'll see if we can try to get off a Wi-Fi connection, maybe be hardwired, and we'd be in a better position to deal with this.
Okay.
So leave the
Thank you.
meeting. Shall we leave the meeting?
I'm hesitant to encourage anyone to leave the meeting. I can see how difficult it was to rejoin it. Why don't we just press mute and turn off the cameras and come back? Mr. Horseman, sorry, not Mr. Horseman, Mr. Taylor, what are you looking for, 5 minutes, 10 minutes? You said,
Lady, I would say somewhere between 5 and 10, and I should be able to advise fairly quickly. And what I can do is I can send an email to Ms. Aswood if people
please.
leave their cameras connected, but actually leave the rooms they're in, if I can put it that way.
Well, I'm going to turn my camera off, but I will not leave the Zoom hearing.
Lady, much obliged.
All right,
you.
thank you. Yes, Mr. Taylor?
Yes, my lady, is that any better?
Much.
Oh, thank you. I can't take any responsibility for that.
The responsibility goes to the top, Mr. Taylor.
Well, credit not in this case. Responsibility, yes. Credit, absolutely not. Milady, so if I may,
Yes.
I think that you have heard how I plan to proceed. Could I ask you to please refer to the bundle that
Uh,
oh,
Mr. Taylor, I don't know.
Yes.
It sounded almost as if you were touching a mute button or close to it, or might have just been speaking away from your mic. Can you just
how is
be
this?
careful not to say anything too important unless you're facing your computer screen?
I'm sure my friends will say I'm saying nothing important, milady. Is this better if I'm directly
Yes.
centered on the screen? Okay, I'll do
Yes.
my best to remain sort of in position. So, milady, could I ask you to turn up the bundle of authorities, please? And it's the one that's marked. It's just marked authorities.
There are a few of them, I think, that are just marked authorities. Which authority are you trying to? Let's see, supplemental authorities. There's 2 binders that say authorities.
It's not supplemental. It's
There are 3
entitled.
binders that are labeled authorities. So what's a particular case you're looking for?
So the particular case is at tab 5, and it's the Salter decision at
Mhm.
first instance.
Okay, I have Salter. Yep.
Yes, thank you. So, lady, as we indicate in our skeleton argument, what is evident from the decision of the Public Service Commission
Mhm.
is that this decision was either not before them and they didn't refer to it, or they had it and didn't either consider its import or misapplied it. And so we say that this case, which was subsequently appealed to the English Court of Appeal and upheld on all grounds, is the seminal case in this area. Malay, I tend to take you through some of the very important principles of this case, and then I'll take you to some of the statements made by the Court of Appeal. And the main judgment in that case was given by Sir Maurice Kay, who of course is a member of our Court of Appeal. So, my lady, could I please ask you to turn over first to paragraph 21
Of the High Court decision.
No, my lady, of the first instance decision at tab 5. It'd say paragraph 22, and that's on page 11.
The High Court decision, isn't it?
You might be in a different bundle than I am. My version has the first instance decision at tab 5.
Oh.
But it doesn't particularly matter. We can look at it together.
What does your paragraph 22 read?
It begins having regard to the reasoning which informs.
Yes.
Yes, Marie. So having regard to the reasoning which informs the approach to sanction in the context of the legal profession, in my judgment, the correct approach to the question of sanction on a finding of serious impropriety by a police officer in the course of his duty is reflected in the principles articulated in Bolton and Salisbury. My lady, Bolton I'll refer you to briefly as well. Justice Burnett goes on to say, the reasons which underpin the strict approach applied to solicitors and barristers apply with equal force to police officers. Honesty and integrity in the conduct of police officers in any investigation are fundamental to the proper workings of the criminal justice system. They are no less important for the purposes of other investigations carried out by police forces, including those on behalf of coroners. The public should be able unquestioningly to accept the honesty and integrity of a police officer. The damage done by a lack of integrity in connection with the investigation of alleged offense may be enormous. The guilty may go free, the innocent may be convicted. Large sums of public money may be wasted. Public confidence in the integrity of the criminal justice system may be undermined. The conduct of a few may have a corrosive effect upon the reputation of the police service in general. And so, Malay, what this sets out is that really we are in the we're in the remit of the public interest here, which is of primary importance in these sorts of matters. And Malady, we say in your consideration of this application. Malady, I'd like to continue on below to paragraph 24.
Mm-hmm.
Now, Justice Burnett in 23 refers to the code of conduct set out in Schedule 2004 regulations. And then he goes on to say, it follows that when considering questions of sanction, which is of course what's being reviewed here, milady, the panel, the chief constable on review, and the tribunal should have regard to the following factors. And the summary there is, the imposition of sanctions following a finding of misconduct by a police officer may have three elements. A, there may be a punitive element designed to punish the police officer concerned and to deter others, particularly if he has been prosecuted and not been prosecuted and convicted. But the imposition of sanctions is not primarily punitive and may not be punitive at all. B, the sanction imposed may be designed to ensure that the police officer does not have the opportunity to repeat the misconduct. And this is the important factor we say. C, milady. However, the most important purpose of these sanctions, particularly in cases involving dishonesty or impropriety in connection with an investigation, is to maintain public confidence in the police service and to maintain its collective reputation. Now, there are obvious reasons for that, and we'll go into some details as we proceed. In sub 2, one consequence of the fact that sanctions imposed in the disciplinary process are not primarily punitive is that personal mitigation is likely to have a limited impact on the outcome. And so, milady, that's very important, and I ask you to consider that as we later go into details of the PSC's determination, what they did. Milady, over the page to page 12. This is sub 3. Again, very important what Justice Burnett says. Cases of proven dishonesty and lack of integrity in an operational environment, of which the destruction, suppression, or fabrication of evidence, or attempts to do so, would be clear examples, are the most serious breaches of the code of conduct. In such cases, the sanction of dismissal or requirement to resign would, to use the language of Sir Thomas Bingham in Bolton, quote, almost invariably, end quote, be appropriate. But there exists, quote, a very small residual category, end quote, where a lesser sanction may be available, as Lord Justice Jackson put it in Salisbury. So this is why Salter is so important, is that once there is a finding of proven dishonesty and a lack of integrity, and Justice Burnett makes very clear that the suppression or fabrication of evidence or attempts to do so are clear examples. That's what happened in this case, the suppression of evidence, milady. The default sanction is termination or an invitation to resign. So what this is not, as a matter of law, this is not a weighing of factors or a finely balanced analysis of whether the conduct was so serious and it ought to be weighed with an officer's personal mitigation, clean service record, good prior conduct, because it isn't about primarily the service and the officer. What it's about is the public interest. And there's a legal principle clearly recognized that, and it started with solicitors in Bolton, that the public interest in the public having confidence in a police service is of such paramount importance that personal mitigation is of little relevance and often not helpful. So, lady, that's why Salter is so important. And so, lady, I'm going to ask you now to turn the page .
Yes, thank you.
Yes, milady, I'm going to ask you to turn over to page 13 of the same judgment,
Yes.
to paragraph 30.
Mm-hmm.
And this is making good my point about what the test. So Justice Burnett goes on to say, rather than concluding that there is a two-stage test, the correct approach for a decision maker is to recognize that a sanction which results in the officer concerned leaving the force would be the almost inevitable outcome in cases involving operational dishonesty. That terminology itself recognizes that there may be exceptions, In concluding that the case is exceptional, the decision maker must identify the features of the circumstances of the misconduct which support a different conclusion. The circumstances of the misconduct, that's very important. So what exceptional circumstances are not is mitigation and an officer's record. So it's what about the circumstance of misconduct would support a different conclusion, recognizing that the number of such cases would be very small. The decision maker would take account of personal mitigation, but must recognize its limited impact. So, lady, this is the sort of way that these questions are to be analyzed. Lady, finally on this judgment, if I could ask you to turn the page to page 14.
Yes.
Paragraph 36. Lady, you'll see about halfway down, Justice Burnett begins, "In my judgment."
Yes.
He says, "In my judgment, it is a factor in cases involving dishonesty which must be considered for the purposes of sanction. It engages a facet of public confidence in the police service. The need for what may appear to be harsh sanctions in cases of this nature arises from the requirement to maintain public confidence in the police service. That is why almost invariably, an officer found to have behaved dishonestly in the conduct of an investigation will be dismissed or required to resign. Whilst exceptionally, an officer may be retained, public confidence is likely to be adversely affected if such an officer were disqualified by his own misconduct from performing a substantial part of his ordinary duties, and, if it were the case, be given a non-job or provided with a role which might otherwise be available to an officer injured on duty or otherwise disabled in some way." And so I pause there because I believe in my learned friend Ms. Greening's submissions, there's a suggestion, and this might have been in the stay application, that it would be open to have Mr. Pereira serve in a lesser role. But what Justice Burnett says and what the law is in that situation is exactly what I've just indicated, that that's also not appropriate because it would be the officer's own misconduct that's caused him, for example, not to be able to conduct his duties in the field anymore and handle evidence because of the invariable difficulties that would arise in someone who's been found to be dishonest or found to suppress evidence in dealing with evidence in criminal cases. So these are the principles that have been established in Salter. And we ask that you have them clearly in mind as you consider the application.
The most important thing in Salter is that this is how we approach cases involving dishonesty.
That's correct, Melody. Dishonesty and integrity. And so we'll come to what the PSC has said in this case about misconduct. Our position is very clearly, and we say the PSC's position in August 2020 was very clearly that there were issues of dishonesty and integrity in then PC Pereira's conduct in the incident in question. Once that arises, Salter is triggered, those principles are triggered, and this is the context in which we say the decision in terms of sanction now has to be analyzed. And we say that because the Public Service Commission did not have Salter in its mind at the time it made its decision, it got off on the wrong foot right from the start. And it's misapplied the law and it's misdirected itself because of that. Milady, what I think I will do next is I plan to take you to some sections in the case of Bolton, which is at tab 6. Milady, really, I don't think it takes the position much further, other than Bolton was the decision in relation to solicitors and their dishonesty, which was then applied in Salter. And as the Court of Appeal in determining Salter, one of the grounds upon which Salter was appealed was to suggest that the Bolton analogy was inappropriate and didn't work in the context of police officers. But the Court of Appeal quite clearly fell on the side that, listen, the public interest in being able to have a profession like solicitors, where it's implicit that there be trust and confidence amongst clients in the court, is directly analogous to a similar situation with the police force, where the public confidence in their honesty and integrity is of paramount importance. So, my lady, Bolton's there.
In Bolton, the court was exercising its appellate jurisdiction.
My lady, it
Not the Court
was.
of Appeal, but the court out that would have heard this after the tribunal.
Well, my lady, Bolton is a Court of Appeal decision. So it's a 1993 decision. It was initially on appeal from the Law Society in relation to, so it would have worked its way up. So, my lady, just the head note on Bolton is, just to assist you, solicitor discipline, appeal from disciplinary tribunal, complaint of professional misconduct by misappropriation of funds, tribunal's finding of unacceptable but not dishonest conduct, penalty of suspension, penalty varied on appeal, whether interference with tribunal's decision appropriate. So the penalty was varied to.
But from the tribunal, did it go straight to the Court of Appeal?
Just having a look. Yeah, no, it did not,
Oh,
lady.
to
It
the
was first at
division
the,
court.
it was first at the Queen's Bench Divisional Court.
Yes.
That's correct.
Okay.
That's correct. So that's on page 514.
So
for
the reason why
2020.
I'm asking is the division
Yes.
court would have been exercising an appellate jurisdiction. I'm now concerned with judicial review proceedings. And there's a difference, isn't there? Because the purpose of the court in judicial review proceedings is to see the wrong that would have occurred. The court's powers are broader if it's exercising its appellate jurisdiction by way of, for example, a rehearing.
Well, it may well be, but really what I'm citing Bolton for is the citation of the principle that was applied. And what I will say is that if you do look at Salter,
Mhm.
Salter is an administrative decision of the Queen's Bench Division by Mr. Justice Burnett. So all of those paragraphs, my lady, that I've just taken you through. So if you look at Salter on the first page,
Mhm.
it's Court Queen's Bench Division bracket Administrative Court. And this is by way of a judicial review of the decision of the appeal tribunal, the police appeals tribunal.
I mean, it's a point that assists you, I would think, in your arguments, because when the court is concerned with judicial review proceedings, they cannot be corrected in principle. At least it's open for you to argue this. It cannot be corrected by subsequent evidence.
Well, my lady,
It really is in terms of the facts and how the decision was made and what the tribunal actually decided and how they reasoned it.
well, my lady, you're quite right. And you will have, it sounds to me like you may have reviewed at least quickly our reply submissions.
I did see that, yes.
Because my lady, what we say, and I can develop this in reply, my lady, if you'd like me to, we say you're absolutely right, that what you should be having regard to, respectfully, my lady, in reviewing the decision is that 17 August 2020 decision of the Public Services Commission.
Mhm.
The law on this is very clear, that the Public Service Commission, sitting as a quasi-judicial tribunal,
Mhm.
is not an interested party
Mhm.
like the police commissioner and Mr. Pereira are.
Mhm.
They have a remit to hear an appeal from, in this case, the misconduct proceedings panel on an impartial basis. The PSC has no interest in this. Their interest really is that the decision is to be correct, and their interest today, before my lady, is to ensure that if there's any question about sort of questions about potentially natural justice, or a question you might have about whether a particular case was cited or not, assisting you to understand. But really, what the court's called is they're not able to bootstrap their judgments, provide further explanation, and they really ought not to be appearing in an adversarial ways if they have an interest, because they don't. And so what we're saying you should be looking at is that judgment, that ruling in 2020. And
Well, I mean, they do have an interest, don't they? If in the context of a judicial review application, as opposed to an appeal, your application is premised on the fact that there was a wrong in their decision-making process.
correct.
And they have an interest to defend that, as opposed to, for example, an appeal from their decision. If, for example, you were dealing with an ordinary employment tribunal appeal, one doesn't expect for the employment tribunal itself to appear in the Supreme Court when the Supreme Court is exercising that appellate jurisdiction. One would expect to just hear from the parties in appeal from the decision made by the employment tribunal. But in this case, you have brought an application for judicial review, and your application has to be developed in a way that establishes that there was a wrong that was.
So our application has to be developed in a way that there are various ways we can put it. And for the purposes of this application, there's a couple of things I will say. Did they get the law wrong? If they got it wrong, the decision ought to be overturned. And we say they clearly got the law wrong. There's no doubt about it. And I say that, and I wish to be clear, like we don't offer, this is not a critical, we're not saying that there was anything that was inappropriate by the PSC at the time. They heard nothing like that. The real question is.
They erred in law.
That's right. They got it wrong. They got it wrong, Malay, and that's why you're able to intervene by way of judicial review. There's a more subtle point, and that is the standard in which they are entitled to review a decision of the misconduct proceedings panel is on the base, in this context, is on the base of whether the finding was unreasonable. They can't do, and this is important, what they can't do is say to themselves, what would we have done if we were sitting as the MPP? Can't do that. That's wrong. They would be misdirecting the manner in which they'd be conducting that hearing. Expressly, and this is in our skeleton. On this basis, and this is what they've done, they have found that the sanction of dismissal was unreasonable. We also say that in the circumstances of this case, it was entirely reasonable for then PC Pereira to be dismissed when there were findings of operational dishonesty, a lack of integrity, gross misconduct, which was all upheld by the Public Service Commission. And when you're in that area and you're in a gross misconduct area, it's an entirely reasonable decision for the PSC to say, in this context, termination is the appropriate sanction. What the PSC cannot do is they cannot say, it would be wrong for them to say, I think we would have done this differently. Absolutely wrong. The unreasonableness standard means, would any theoretical misconduct proceedings panel have decided that termination was incorrect? Was it so wrong as to be unreasonable? And quite frankly, we're nowhere near that standard here in terms of what was found by the PSC. They don't get to substitute their own judgment, their own discretion. And you'll see when we go through, and I'll remind you of their decision, as they go through it, they're aware of that standard. They say not unreasonable, not unreasonable, not unreasonable. But because they didn't have Salter, and it's just one of those things that happens. It's a seminal authority, wasn't in the judgment, and the principles weren't considered. And it's clear in how they dealt with mitigation that they didn't have it in their mind because they don't ask themselves the right questions, that their decision that dismissal was unreasonable is simply wrong. And that's why we're asking you to intervene. So that's my response. So I hope I've answered your question about the standard review, and I'm obliged, lady. Do you have anything else in that area? Or and as I say, what I would like to do, and this is important. So, and I'm happy to take you to the authorities now and to our supplemental skeleton. Because when, my lady, when you say that they have an interest in defending the decision, I don't think I would frame it in those terms.
Not necessarily, no, I didn't say defending the decision, defending the wrong, whatever it is that you say.
Yes,
Is the
with
wrong
that,
that occurred.
with that I agree. With that I agree. And so, my lady, what we say is that the PSC's interest is, when you say defending the wrong, what the PSC's interest really is to make sure that the case is decided correctly. And their interest, and I'll come on to the authorities.
Or
Their
speaking to it.
Yes, correctly, their interest is to assist this court
Mhm.
with candor and being open and candid about what took place, not by way of additional evidence, not by way of further justification for the decision they made, but for example, cutting directly to it, lady, we did not consider Salter. We didn't have it. We don't know that. I think they didn't. We say they didn't. It's not in the judgment. The supplemental submissions, and we'll come on to this, dance around it. It's mentioned. They sort of weave around it. I think that means they didn't have it. That's what I say. You may wish to ask Mr. Horseman when it's his turn. But the other thing that makes it very clear, very inappropriate, and when I mean inappropriate, I mean not something that you consider. The other thing you'll see in their submissions is you will see bootstrapping of an exceptional circumstances analysis now. It's now February. Their decision was in August. And that, on any analysis, in the context of a quasi-judicial decision maker is, I mean, you know, you're 30 yards offside and in alone on the goaltender. There is no question that that is inappropriate, not the way to go about it. And I will add here, just while we're on this discussion, there's a very good reason why that is. You can't engage in a post facto engineering of an issue like this that you ought to have considered because you're not in the context of that hearing. So I can come on to that, milady, in reply. But that's what we say about their interest in defending the decision. Really, their interest is in getting it right and assisting you if there are any things they didn't consider as a matter of law. That's their interest. And as I say, I'm happy to do it now, milady, if you wish, but my intention was to wait until I heard what my learned friend said and then take it to the authorities on
No, I didn't mean to take you off course.
No, it's
I
fine.
thought it was helpful to make the observation while you're taking through the authorities, because I would want to keep in mind when looking at these authorities, whether the court was exercising its appellate jurisdiction or if it was in fact reviewing a decision of a public body.
Yes, and as I say, the Salter first instance decision clearly was. So I hope that assists. And Bolton was really, they took the principle and said, this is a principle that's equally applicable, a legal principle in the context of review of police misconduct. Just analogizing between solicitors. So I'm very much obliged. If I could, I'd like to ask you to just, if I may, refer to close out Salter, the Court of Appeal judgment. I have
Court of
that.
Appeal judgment.
I'm sorry, my lady?
You want for me to look at the Court of Appeal judgment in Salter?
Yes, please.
Okay, where's that?
I have it at tab 7.
Let's see. Yes, thank you.
Yes, my lady. And again, you'll find that the first instance decision was upheld on all accounts, but there are some helpful paragraphs. I think I think I'd like to first refer you to page 9, paragraph 21.
Okay.
And so this is the main judgment by Sir Morris Kay.
Mhm.
In paragraph 21, at the end of the 5th line, he says, it is also obvious that the operational dishonesty or impropriety of a single officer tarnishes the reputation of his force and undermines public confidence in it. In these respects, the similarities between solicitors and police officers justify the analogy provided.
I didn't
that
want to
type-
stop you there, Mr.
Yes,
Taylor.
ma'am.
What were you reading from? What paragraph?
21 on page
21.
9.
Okay, thank you.
Yes. So this is just the last few words on the 5th line,
Okay.
beginning, it is also. It's also obvious
My
that the
paragraph 21 starts with the panel also had written evidence.
my lady, you may be in the first instance decision.
No, this is the Court of Appeal decision. It's quite clear. It's unless,
Tab 7.
yes, tab 7, paragraph 21. The panel also had written evidence.
Mine is I turn to the criticism of the judge.
Yes, mine too. I'm a bit confused.
That's strange, unless it's, oh, I see, you put it, I have 2 cases in the same tab.
Oh, my
That's
my
fine,
apologies.
that's fine, let me just separate it. Because I do have the Court of Appeal decision that starts in the tab, but. All right, so let's get a paragraph 21 in this. All right, yeah, the other decision I had was Darren Williams and the Police Appeals Tribunal.
Oh, yes, okay.
All right, so I'll just have to remember that when you come to refer to it, that's also at tab 7. Let me just mark that for a minute.
I'm obliged, my lady. Apologies again.
Yes, okay, I see it. I turned to the criticism and you said midway through, it seems to me.
My lady, about the
It
5th
is
line
also-
down at the end, yes. It is also obvious that the operational dishonesty and impropriety of a single officer tarnishes the reputation of his force and undermines public confidence in it. In these respects, the similarities between solicitors and police officers justify the analogy provided. So as I mentioned, one of the grounds of appeal was that the analogy as between solicitors and police officers wasn't appropriate. Court of Appeals rejected that and said they both deal with public trust and confidence, which is why a single officer's dishonesty or impropriety can tarnish the entire police force.
Mhm.
Turning now, going on to paragraph 22, milady, and we're about halfway down. I'll count, I think we're 7 lines down. About halfway through that sentence, it begins, it is a primary duty of police officers. Milady, did you see that?
Yes, I see it.
Yes, it is a primary duty of police officers to gather and to preserve evidence.
Mhm.
It is what they do. It is what the public rely upon them to do. To destroy or procure the destruction of evidence is, in the words of Mr. Beggs, QC, inimical to the office of constable. And I'm going to pause there. I'm going to make it very clear. This was a case, Salter was a case of destruction of evidence and a senior officer instructing a junior constable to do so. This case we are dealing with is a case of then PC Pereira making a conscious decision, as the PC called it, a willful decision, to turn off his body-worn camera at the outset of the incident that took place. What you're going to hear, I suspect, you're going to hear 2 things. You're going to hear the submission that somehow evidence wasn't destroyed or evidence wasn't lost because of that. We say that is on its face nonsense, because we would have an independent recording of what went on at this stop had PC Pereira not willfully, as the PSC found, turned off that body-worn camera, I suspect you will also hear a strange logical proposition that the fact that somehow, because there was no assault found, that means there was no reason to turn the camera off. It's a very strange submission. I don't understand it because we don't know what we don't have, and we don't have a recording. So what
I
I'm
think
going to say,
I might have also been given some insight to the fact that there was no policy in place that mandated for the body camera to be on.
I think you will hear that. Here's what I will say. There was no policy in place. The answer is it's absolutely irrelevant, because when an officer attends a scene, as this police constable did, has a camera on, that is a device that is issued by the police service that permits, at least in terms of what the camera captures, an objective record of evidence of what took place at this stop, and he willfully turns it off, it doesn't matter what the policy is. That is a complete and utter red herring. He attended the scene of this. You'll also hear that it happened in a few seconds. Well, it's interesting that he quickly was able to willfully turn that device off. And because of those actions, we do not have a record of what took place. So I invite you, we say is, in this context, destruction and suppression, there is no distinction. There is no difference. There is no thin nuance. It is the same in this context.
Mhm.
He had the ability to capture what took place, and he willfully decided not to do so. And while I'm here, and this is really important, and I will get to future deployment, my lady, I'm not a defense lawyer. My learned friend, Ms. Greening, has been one and is a good one. And I can only imagine what Miss Greening or one of her colleagues would be able to do in a prosecution if this police constable is reinstated and finds himself involved in the evidential chain.
Mhm.
And that is why this is so crucially important. And it's why Justice Burnett made so clear how important this is when he said the guilty may go free, because it doesn't take much for a jury to decide that if an officer has willfully suppressed, precluded the collection of evidence, that he may do so again. And that may not be fair. I wouldn't suggest it's unfair, but that's just the way it is. And the public importance of this trumps anything else. It is at the top of the pyramid, and that's the difficulty.
Mhm.
So, my lady, that's why we say that there is no difference and there's no reasonable distinction between the destruction and Salter and what we have in this case. Very important, we say. And so, lady, if I could ask you to just remain with the Court of Appeal decision and down to paragraph 23.
Yes, one moment, please.
Yes, yes, ma'am.
Yes, thank you.
Yes, my lady. And I should say, just to close off that point, the other thing that is not in the PSC's decision at all is a consideration of future deployability. It's just not there. It's another serious error in terms of what legally must be considered in the context of this sort of case.
Yes.
Yes, Milady. Moving on to paragraph 23, if I may, and this is back to personal mitigation, but I think it's helpful to understand the Court of Appeals view on this. Here, Sir Morris Kay says, as to personal mitigation, just as an unexpectedly errant solicitor can usually refer to an unblemished past to the esteem of his colleagues, so will a police officer often be able to do so. However, if the importance of public confidence, the potential of such mitigation is necessarily limited. And just skipping down a few lines, Sir Morris starts, he says, like Justice Burnett, he says, I cannot see this as, quote, a finely balanced case, end quote, or one of the, quote, very small residual category, end quote, in which operational dishonesty or impropriety need not result in dismissal or requirement to resign. So just to be very, very clear, the Court of Appeal has adopted the very same reasoning of Justice Burnett in what this mitigation test is and where the jumping off point is.
Yeah.
Lady, finally, if I could ask you to turn over to the final paragraph at page 11, paragraph 31.
Yes.
So this is Lord Justice Gross in a supporting opinion or supportive ruling. I also agree that this appeal must be dismissed for the reason given by Lord Justice Morris Kay. As he's underlined, this is a very sad case indeed, and I find it impossible not to have sympathy for Mr. Salter. His insuperable difficulty, however, is that the operational integrity of the police is of fundamental importance. A central role of the police involves the gathering and preservation of evidence. The destruction of evidence is inimical to the office of constable, all the more so when it entailed an instruction to a junior officer to do so. For my part, too, the practical problems that would attach to any future deployment of Mr. Salter as a police officer reinforce the conclusion to which I feel driven to come. So, milady, I think there, if I may, there likely is a human tendency in particular circumstances, certainly in the Salter case, to feel some sympathy for an individual officer who's caught up in a situation like this. That personal sympathy, though, because of the public interest involved, doesn't permit the inevitable conclusion in these sorts of cases almost invariably that dismissal is the appropriate sanction. And that's Salter.
Before you come away from Salter, what did Lord Justice Stanley Burnton contribute to this? Because you've taken me to the concurring remarks of Lord Justice Gross. They come and follow just after Lord Justice Stanley Burnton.
Lord Justice decision. I'll just take you to some of those. So, my lady, they begin on page 10.
Yes.
So paragraph 28, lady, he says about halfway through that paragraph, an actual or perceived lack of integrity disqualifies a person from acting as either a constable or in a police supervisory role. The tribunal did not explain how Mr. Salter could be fit to be a constable, but not to be a supervisor. The reason for its conclusion was either irrational or unreasoned, and on one or both grounds was defective. Here, milady, he's analyzing the decision that the sanction shouldn't be termination, but rather demotion. And milady, that's where I went back to what Justice Burnett said, that the demotion doesn't work either because of the factors we described. He also indicates in paragraph 30, well, he does say 26, lady, obviously, I agree the appeal should be dismissed, and I agree with the reasons given by Lord Justice Morris Kay. He says, I would, however, add, I consider the decision of the PA2 to have been defective and liable to be set aside for 2 reasons additional. So he's added these reasons Otherwise, he's entirely concurred
Yeah.
with Sir Morris Kay. So it is a, as I described it, a unanimous, we say very strong decision of the Court of Appeal upholding Justice Burnett's first instance. So, lady, what I intend to do now is go through those aspects of the PSC decision that we think are particularly important. Lady,
Yes. That PSC decision is before me as an exhibit to Mr. Pereira's affidavit. So
Lady,
I will,
that's
The
perfectly
commissioner's affidavit.
fine.
sorry, Mr. Horseman?
I said I thought it was exhibited to the commissioner's affidavit. Did you say Mr. Pereira?
I
Everyone's.
have it as an exhibit to,
No. Okay.
but in any event,
Yes, my lady, I'll refer you
have
to paragraph numbers, and I don't. So I think be able to work.
that will
with
be
it.
helpful. Thank you.
Yes, of course. Where I'm going to begin, if I may, this is page 18 of the decision, at paragraph 51.
Mr. Walker, don't forget, sorry, Mr. Taylor, don't forget that I can't hear you clearly when you come away from the computer screen.
Understood.
Thank
So,
you.
I'm going to just hold the binder with me, my lady, so that I don't move from the center.
Okay.
Can you hear me sufficiently well now?
Yes, thank you.
So I'm going to ask you to refer to page 18 of the PSC decision.
Okay. Yes,
So, my lady, can I refer you to paragraphs 51 and 52?
Yep.
PSC says that the MPP found that the appellant had willfully turned off his camera.
mhm,
And the PSC says the PSC cannot say the finding was unreasonable in the circumstances. And my lady, there we see that the PSC is alive to what their review sort of jurisdiction is, unreasonability. So we've confirmed that then PC Pereira willfully turned off the camera, not an accident, willfully did so. Paragraph 52. The MPP did not accept the appellant's explanation and described his account as implausible. The MPP, by finding the appellant had willfully turned his camera off, inferred that the appellant was being untruthful in giving his side of the story. The MPP did not accept that the appellant was instructing PC Bowden to turn his camera on, and the PSC is unable to say that this finding of fact was unreasonable. Giving an inaccurate or implausible account in order to shield himself from criticism and potential misconduct charges was, in the PSC's opinion, gross misconduct. No editorialization necessary. Lady, can I now ask you to turn over to page 20 of the ruling?
yes,
Beginning at the top at paragraph 57.
Yep.
In assessing the misconduct, the appellant was clearly culpable in denying he had requested PC Bowden to turn his camera off with an explanation that was found by the MPP to be inaccurate. Honesty and integrity are fundamental requirements for a police officer, and it is imperative that the public have confidence in the Bermuda Police Service. My lady, I'm going to pause there, because it's at this point that the PSC goes on to deal with operational requirements. And my lady, again, just putting a pin in something I may deal with further in reply. I think you're going to hear, we say strikingly, from the Public Services Commission that somehow there was no finding that PC Pereira's honesty and integrity were called into question. What we say is that on the face of the record that you ought to be considering this ruling, that is an extraordinary position to take. Why in the world would the Public Services Commission say that the appellant was clearly culpable and that honesty and integrity are fundamental requirements for a police officer, and it's imperative that the public have confidence in the Bermuda Police Service? Of course, they found he was dishonest and he had questions surrounding his integrity because of the way he handled this situation. To reverse engineer that now is strange. I'll say that. I'm going to ask you to move on, and we'll go through together, if you don't mind, paragraphs 58, 59, and 60.
Yes.
These are important. PSC says, the real aggregating factor in this case, as described by the misconduct proceedings panel, the appellant's implausible account of what transpired when he stated that he asked PC to turn on his camera on and denied that he willfully turned his own camera off. In terms of the harm caused, there was no physical harm to be suffered by Mr. Grant at the hands of the appellant by reference to any unjustifiable assault. There was no evidence of any physical injury attributable to the alleged assault. The only harm, and I pause there, and here is another pin that makes it very clear, Saltus is not in their contemplation. By calling it the only harm, the PSC has put themselves in the incorrect frame of mind, and they're misapplying the law, because we know that the primary harm is the reputation of the Bermuda Police Service and the undermining of the public confidence in policing. So they say the only harm, as if it's secondary or not as important as the unjustifiable assault. And so another piece, another thing that very clearly indicates that the PSC is on the wrong track here. They go on to say, giving an untruthful explanation in order to protect himself from criticism does undermine the reputation of the Bermuda Police Service. Done and dusted. Apply the law to that finding, and the conclusion we say is absolutely inescapable. But because they don't have the right authority, they're continuing down the wrong avenue, even though they're factually finding the very factors that Saltus is pointing us in the direction that this person cannot be employed by the service anymore. So paragraph 60, they say, against those factors, Order 3410 required the MPP to have regard to the record of service of the appellant as shown by his personnel record. That is absolutely correct. 3410 expressly says that they must consider the service of the appellant's personnel record.
Yes.
I make 2 points on this, very important. Lady, you may not have this before you because I think it was sent to you in the context of the stay.
I do have your stay binder, so I might have it.
Afraid by email. But I can circulate it afterwards and my learned friends have it.
Is it in your binder of supplemental authorities for the stay application?
I'm not sure that it is, milady, but it was certainly sent by email.
What are we concerned with?
So, milady, the point I wish to make is that the Police Conduct Regulations 2004 in the UK at the time of Salter say the same thing. So this is not a situation. This is not a situation, milady, where the applicable conduct regulations in the UK are silent on mitigation.
I have it. Is it your tab 2, the police conduct orders, 2016? Yeah,
Or the Bermuda police conduct orders.
right.
Right. So that's the Bermuda orders, which encompasses 3410, which we don't dispute applies.
Okay. One moment, because I think, I feel as if I came across what you are referring to. Could it have been in Mr. Horseman's bundle? He had guidance notes.
No, those are different. Those,
Okay.
the guidance notes that are in those,
Yeah.
in that bundle are different. Right?
Okay,
Well, lady, we can,
you can email it.
yes, and two things. My learned friends have this. So
Okay.
this is statute, UK statutory instrument 2004 number 65. It's the Police Conduct Regulations 2004. And these, of course, predate the Salter decision. So they're in place at the time Justice Burnett and the Court of Appeal considered the Salter case.
Okay,
And Regulation 36(1)A reads as follows. It's entitled Personal Record to be considered before sanction imposed.
36(1)A you said?
36(1)A, my lady. Yes, correct.
Okay,
Thank you. And it reads as follows. Where the question of the sanction to be imposed is being considered,
Mhm.
the tribunal or persons conducting the hearing shall have regard to the record of police service of the officer concerned, as shown on his personal record, and may receive evidence from any witness, whose evidence would, in their opinion, assist them in determining the question. So in the UK, in the Salter
Even with that in
context,
place, you still had Salter
that's
and
correct.
Burnett's
That's
decision
correct.
was upheld by the Court of Appeal.
That's correct. And to put it in pragmatic terms, as I would describe, the section, the applicable rule requires you to consider personal mitigation. It says nothing about the weight that must be given in any particular context, which is very important, related, because you can imagine a situation where a particular officer uses flowery language to criticize a superior in front of his other officers. And that conduct may well be misconduct and subject to sanction. But because it doesn't bring the police service into disrepute publicly, it might be appropriate that there be a written warning or there be a requirement to apologize to the superior officer. So all this does, my lady, all the police conduct orders in Bermuda do, all 3410 does, is say that you have to consider it, but it doesn't say the weight to be given. Salter makes very clear what weight is to be given in this context. Very important. So we don't, 3410 says what it says. It's the application that's crucial, we say, my lady, for your consideration in this case. So but what happened here, unfortunately, because again, the PSC didn't have Salter in its mind, is it gave far too much weight to the personal record of PC Pereira at the time. And that is a significant error and contrary to the law. And so that's where,
I mean, just put more plainly, a first disciplinary offense can be serious. It's capable of being serious enough to justify the dismissal, is your submission.
oh, entirely. And remember, the PSC has expressly said in their decision, not only that the conduct was very serious, but they affirmed that it was gross misconduct. So absolutely, lady, you're absolutely correct, and we would agree with that. That's exactly the case. So what we would say to sum up, so I've taken you through what we say are the important key findings in that PSC decision. So here's what that decision says in summary, the three things we say from those paragraphs. There's clearly operational dishonesty, and there's operational dishonesty twice. It's the willful turning off of the camera such that the evidence that ought to have been collected by that camera was not. And you have the PSC's very clear language around the reason why that camera was willfully shut off. And there was clearly a finding. The PC Pereira went further and was dishonest about why he did it. So in the MPP proceedings and in his discussion, he said, and lady, you'll remember what his explanation was, because this was caught on the body-worn camera before he willfully turned it off. The explanation was that he had told PC Bowden, cameras off, as in, PC Bowden, your camera is off, turn it on. Not accepted, and the PSC said clearly that he did so to shield himself. He made that story up to shield himself from from disciplinary proceedings. The third thing is the finding of gross misconduct was undisturbed. And so we say that in that context, and really it's unfortunate that Salter wasn't there. Had the PSC had Salter before it, had it been properly been addressed on the principles of Salter, they would have got it right. And they clearly didn't get it right. And we say, Milady, that this court should step in and correct the mistake. And it may well be, and I think, again, this illustrates the difficulty with not having the correct authority. It may be, and I don't know, I'm editorializing, that when the decision was made that the finding that there was an assault was unreasonable because of the video that was captured before the camera was willfully turned off, that sort of exonerates PC Pereira. They didn't focus on the right questions because they didn't have the right law in front of them, I'm afraid. And so, my lady, now that we have the right law, we're asking you to intervene. And my lady, what we're asking you to do is we're asking you, because we say the outcome is so inevitable, we're not asking you to remit this back to the PSC. And we have very good reasons for that. They're twofold. One, the outcome's inevitable once the Salter overlay comes into play.
Yep.
Lady, two, certainly the police commissioner has concerns in the context of this particular case, that the manner in which the PSC has filed supplemental submissions to bootstrap its position. Again, as I say, I'm going to hold my reply depending upon what my learned friends have to say about this. But those submissions suggest, lady, be thinly veiled about it now, that you're the appropriate person to step in and deal with this. Because those submissions have
They've
gone
lost the
further.
impartiality and the independence that you would need for a tribunal.
That's correct, my lady, because what they've done is they've gone too far. And let me be very, very clear. We know what impartiality and bias is about. I'm not saying in any way, shape, or form that the members of the Public Services Commission are biased at all in a real way, but I don't have to. These submissions, the way that they've tried to backfill and support their decision with things that weren't before them at the first hearing, and I'm afraid to say that the way that they've described some of the actions of Police Constable Pereira in the heat of the moment would give anybody, any reasonable person sitting in the back of the PSC hearing, a reasonable apprehension that they can no longer hear this in an impartial fashion. And so, my lady, what we're asking you to do for two reasons. One, because we say there's an inevitability here, the decision will be the decision, and there's really no point in sending it back. And two, because even if you did, I'm afraid to say that there's the ordinary person sitting in the back of the courtroom would have a reasonable apprehension of bias in a rehearing.
Yes.
Ladies, subject to any reply I may have, unless you have any questions. Those are
I do have
those are
one
my submissions.
question.
Yes, ma'am.
Do I need to concern myself with the decision of the misconduct proceedings panel?
You don't.
Okay.
You don't. And I can explain why the PSC decision is the decision that is what I will say in play.
Yes.
The MPP decision's there. It has been produced in evidence for completeness,
Mhm.
but the decision that you are being asked to review
Mhm.
and to grant a writ of certiorari is the PSC decision.
Yeah.
That's
Okay.
the decision. Thank you, my lady. Very much
Thank
obliged.
you very much. Now, I note that it's 12 o'clock. Can I just get some idea from you, Mr. Horseman, Ms. Greening, as to how long you were hoping to have afforded to you to complete your submissions? I did not have this matter fixed for the afternoon session. I know that we've had a late start. What are your thoughts and what do you propose?
My lady, on behalf of the PSC, I was going to suggest that maybe I'd follow up. This is actually, I think, as everyone's said, is really a fight between the commissioner and Mr. Pereira. And I take my friend's point. You know, we're supposed to be sort of on a neutral stance. I would be very short. I'm not planning to go through any submissions or any great law. I would just make a few points
Yes, that's helpful.
after that. So, I mean, myself personally, I wouldn't imagine that I would be more than 15, 20 minutes
Oh, that's
tops.
very helpful. Thank you. Let me see what Ms. Greening has to say about how long she would likely be, because it is a consolidated action. So I should hear from her as well. What do you say, Ms. Greening?
Yes, good morning, my lady. I do have submissions to make. I think they will take about 45 minutes to an hour. I am
Ms.
interested
Greening,
in
you're
hearing what
frozen
Mr.
in your
Horseman does
frame.
have
One
to
minute,
say.
one minute. You froze on my screen. You're back now, yes. They'll take 45 minutes to an hour?
Yes, I am. I had thought that I'd hear what Mr. Horseman has to say. I'm interested to hear what the PSC has to say, and then I would follow up. Just the only other thing is that I would be very grateful for a 2-minute comfort break if we are going to continue now,
Mhm.
and that's all.
So it sounds as if it's realistic that we would finish by 1 p.m. That would
Yeah.
be good. Okay,
Yes, I would
let's
think so.
aim to do that. I note that the time on my computer screen reads 12:01. Should we resume at 10 past 12, or is that cutting it too fine?
That's plenty of time.
Okay, all right, thank you.
Thank you.
Do not leave the meeting, please. Just mute your cameras and thank you, and the audio.
No.
Okay, Ms. Greening, can you hear me?
Yes,
Good.
lady.
Yes, I'm going to from Mr. Horseman first, so is that correct?
Yes.
Okay. Yes, Mr. Horseman.
Thank you, my lady. My lady, I'll be very short because I do take the point that the PSC are supposed to be neutral in the circumstance, and to the extent my submissions gave a slightly different flavor. Obviously, we were trying to explain the basis for the decision, and I can understand my friend's concern. Let me just say this. As I said in my submissions, my lady, and I'm just going to try and summarize them because the original decision to terminate Pereira by the MPP was clearly based on the assault as well as the other two factors, the turning off of the camera. And so once the assault went, and it was found that there was no unlawful assault by PC Pereira, the PSC had to consider what sort of flowed, or what should be imposed based on those two incidents, so to speak. And clearly, as you'll see in the judgment of the PSC, they found that there was no basis, or they couldn't say that the finding by the MPP was unreasonable. And I'm not trying to backtrack from the original decision at all, but the PSC clearly had in its mind that the sort of finding by the MPP that the camera was turned off and his implausible explanation, was gross misconduct. And they clearly had it in their mind that, he could be terminated just for that. But what's also clear, my lady, is when you look at the judgment, they took into account that there was no operational policy in place regarding the use, which they did find, that's recited in the judgment.
Yes.
And I could tell you the PCC wrestled heavily with PC Pereira's, so it's a quote unquote explanation. And you see the judgment of the PSC refers to that the MPP sort of inferred dishonesty. And clearly, listen, I'm not trying to backtrack. That was clearly the inference by the MPP, that they didn't accept it. They didn't accept his explanation.
Mm-hmm.
And as I said in my submissions, and as Mr. Taylor has pointed out, we didn't come out and say the PSC found that he was dishonest. What we said is, or what the PSC said, we couldn't say that their finding was unreasonable in the circumstances, which is obviously the test. And in those circumstances,
They proceeded on that factual basis.
yeah. Well, we proceeded on the factual basis, and that's what they had to do. We couldn't say that finding was unreasonable. But when my learned friend says, "Well, you go on to consider the sanction that the MPP imposed, whether that was unreasonable," clearly they had in their mind the assault as well, and the cover-up of the unjustifiable assault. The PSC were alive to the issue that operational dishonesty is clearly serious misconduct. and could result in dismissal. I don't know if I could just take you to, I mean, my learned friend is taking you through the particular paragraphs. And the complaint being that we didn't cite, the PSC didn't cite Salter in the decision. You know, we didn't cite any case law in the decision itself. But the PSC clearly considered that this was, you know, serious misconduct, but in circumstances, and you'll note in the judgment where it was sort of exceptional. I mean, and I'm using that now, but it really weighed on the PSC's determination that there was no policy in place regarding the use.
Do you accept, Mr. Horstman, that the PSC did not operate with the guidance of the principles under Salter?
Yeah, and my lady, I would say this: while Salter wasn't quoted, you know, it clearly considered the fact that dishonesty, operational dishonesty, if it was that, you know, could clearly result in dismissal and was serious misconduct. I mean, that's plain in the decision. The question, I guess, is the criticism of the PSC judgment is that it gave too much weight to his Mr. Pereira's previous good character, and you know, I don't want to backtrack. I can't go behind the judgment, and I don't think it's probably appropriate for me to talk about deliberations. But I will say this: that the principles. What the PSC did have was the UK guidance, and was particularly referred to the paragraphs, the sections from 4 to on. So if you were to take a look at the UK guidance that I had in, it said tab 2 of the submit of the authorities. Do you have it, Melinda?
Yes, I see it. Thank you.
Yeah. So if you were to go to section 4, and particularly looking at, you'll see in assessing seriousness and going down, you'll see those factors that were cited in relation to the judgment, and they're specifically referred to. And if you were to continue on section 4.25 on page, if you go to paragraph 4.25, where it says operational dishonesty and propriety or corruption, where it specifically refers to Salter. So, you know, these were reviewed and considered, but again, I don't know how far I can go and say what went on in deliberations and be giving evidence, because I think
the question is doesn't call for any provision of facts. It's an analysis. Would you, my question to you really is, would you accept that their decision does not give way to the principles that were provided by Salter?
Plainly, it doesn't specifically cite Salter,
but even without citing it, the approach that's given, I mean, the ratio in Salter is where you have dishonesty or issues of integrity involved, involving a police officer. Paramount consideration has to be given, obviously, to the reputational harm of the police service itself.
Right.
And that's not an equal balancing exercise that you would give to the individual rights of the police officer. I mean, I've said it loosely, but that's the general principle, as I understand it from Mr. Taylor's submissions, that comes out of Salter.
Yeah.
So whether they cited it or not, would you be able to assist me with some analysis from your perspective as to whether or not that was in fact done by the PSC in their decision?
Yeah.
Is their decision consistent with the principles of Salter?
Well, they considered what I should say is the seriousness of the conduct, and they clearly considered that this was gross misconduct.
Yeah.
And they clearly, it was clearly in their minds that PC Pereira could be dismissed for this particular thing.
Yeah.
But in the circumstances where he had been found not guilty of the assault, and in looking at the fact that that they, when evidence was given that there was no policy in relation to the use of the cameras, and that is clearly set out in the judgment, it was felt that some blame probably could lie elsewhere, in terms of which was mitigated in itself and somewhat, I don't want to sort of say extraordinary, but it was surprising that there was no policy in place, and that was found to be mitigating, which was put into the judgment. And in terms, I think if you look at the judgment, the crucial part.
Yeah.
Yeah.
Of 58, paragraph 58, where they clearly found that the real aggravating factor in the case was his implausible account of what's transpired. So, they found that was very serious. They found that it was aggravating. But in the circumstances where there was no policy in place, they clearly, under the police conduct orders, were to consider his previous unblemished character, and never been in trouble before with any findings against him.
Mhm.
They did give weight to that. Now, what I would say is, you're doing a fine balancing act, and it would have been helpful had the judgment sort of specified that. But I think they took into account the principles that, listen, this undermines the confidence in the Bermuda police. But in these circumstances where there was no policy, and remember, where the PSC really wrestled is this. He admitted saying cameras off, and this was a question or finding as to whether, based on his intonation. And again, I'm not trying to go back behind the finding, but it was it was a difficult decision. I'll put it that way. But when you see the PSC saying giving an untruthful explanation or to protect himself did undermine the reputation, they had clearly had that in mind when considering the decision or the penalty. The question is my learned friend's criticism is, did they give too much weight to his good character? And that's going to be a question for you, my lady, looking at the judgment. I mean, I don't want to. I could go on. This deliberation took hours and, in fact, days on many hearings, and it was a decision that was not arrived at lightly. I would say that. But I will say they took into account the factors that Salter enunciates. But you'll have to glean from the judgment yourself. I mean, I can't tell you. I'd almost be given evidence of the deliberations and adopting a sort of neutral stance here. It probably wouldn't be appropriate for me to do so. So I don't know that I can assist you a whole bunch further, but I would say clearly they had the general principles in mind, but whether I'll leave it to you to make a determination whether. I think you have to read the judgment and say, did they give too much weight or not? But they did find that there were extraordinary circumstances not having a policy in place, and that PC Pereira found himself in a very difficult situation where he's accused, as I think, of where the PSC overturned the finding of an unlawful assault. I mean, he was accused of something that he didn't do. And they found that he had been put in a very difficult position, and they took that into account. And I think if you look at it, you'd almost have to say, were these circumstances, in order to overturn the decision, were these exceptional circumstances? And with the PSC bearing in mind that, yes, this was serious, they clearly felt that this was an exceptional case. And I think you can glean that from the judgment. So I'll go no further than that.
Thank you, Mr. Horstman.
Thank you.
Ms. Greening.
Yes, milady, thank you. My notes. Yes, milady, I think it's a good time, having heard my learned friend's submissions, to remind her ladyship what your role, what this honorable court's role is in this in these judicial review proceedings. And my submissions go into the law in that respect by looking at the constitutional provision which deals with the PSC at section 84(7) of the first schedule of the Bermuda Constitution Order.
Okay, so what binder am I looking at now?
Milady, I filed two sets of submissions. One of them are on the stay, and then I tweaked them in a minor way, and then filed submissions on the stay, submissions on the JR.
Okay, so I have your submissions on the JR in front of me.
Submissions on judicial review hearings.
Yes, it's the 1st of
Yes.
February submissions.
Yes.
And
Could I just interject really quick, milady?
yes,
I've just had something extremely urgent come up. I don't think, as this is a dispute between the
are you asking to be excused?
commissioner. Yeah, would it be okay? I understand there's going to be a recording of the proceedings.
Yeah.
So I'd be obliged if I could leave with no disrespect, but I don't think I would be called upon to answer any more questions at
Don't
this point.
anticipate that you will, unless anyone has any issue with that. I'm fine with you leaving the hearing now. Thank you.
Thank you, and I'll get a recording later. Thank you, ma'am.
Thank you, Mr. Horstman.
Yes.
Yes, Ms. Greening, I was saying to you, I have your 1st of February submissions.
Yes.
But in terms of a binder, I don't have a binder from you.
There's no binder.
Okay. So when you refer me to regulations, whose binder are you referring to?
It's just contained within those submissions.
Oh, I see. Okay, yes.
And at section 84(7), subsection 7, it states, subject to the provisions of subsection 5, which aren't relevant to these proceedings, of this section, and of any regulations made thereunder, in the performance of its functions under this Constitution, the Public Service Commission, and I have underlined the bit here, shall not be subject to the direction or control of any other person or authority. And at this stage, milady, I am respectfully asking this court to put this at the forefront of their mind when they are considering their role in this judicial review. And I go on to say at paragraph 2, this provision gives the Public Service Commission the final authority and dictates that it not be controlled by any other individual or authority, including this honorable court. I then go on to draw a parallel to the provision at section 71(6) of the Constitution, which deals with the now DPP's decision-making power.
You can take it as these submissions as read. I have seen your submissions on this point. If you want to take me directly to the decision of the Honorable Chief Justice, Mr. Hargan, and how he dealt with it, I'm happy for you to do that.
Yes. So, and my argument, as you can see from reading the submissions, is that there's a test, a clear test, as laid out by the Chief Justice in that recent case, that must be applied when looking at decisions by the DPP, made by the DPP, and decisions made by the PSC. And I'll take you straight to page 9 of that 2021 case at paragraph 16. Paragraph 16, 17, and 18 are the relevant paragraphs in my submission to this case.
Yep.
Paragraph 16. It is now established that the courts retain jurisdiction to review the decisions made by the DPP as to whether or not to institute and undertake criminal proceedings against any person in respect of any offence against any law in force in Bermuda. C. G1 Mowat, the Director of Public Prosecutions of Mauritius, Privy Council Appeal number 31 of 2005 at 17 and 18. However, the cases also make it clear that the power to intervene, your power, milady, to intervene in such matters would be, quote unquote, sparingly exercised. R versus DPP ex parte C 1995 1 Criminal Appeal Review 136, quote unquote, very rare indeed. R versus Propitiate Crown Prosecution Service 2004. Immigration Appeal Reports 54949, quote unquote, highly exceptional remedy, Sharma versus Brown Antoine 2007 1 WLR 780, and quote unquote, only in very rare cases, S versus Crown Prosecution Service 2015 EWHC 2868 admin. The rationale that underpins the reluctance of the courts to intervene in prosecutorial decision-making, and I apply that to the PSC's decision-making power as well, is primarily due to the fact that, one, under Section 71A of the Constitution, the sole authority to decide whether to institute and undertake criminal proceedings against any person in respect of an offence against any law in force in Bermuda lies with the DPP. And in the exercise of that power, the DPP is not to be subject to the direction or control of any other person or authority, identical in terms to Section 84(7). 2, the decision involves an exercise of an informed judgment as to the likely outcome of the criminal trial before a jury. That's in relation to the DPP's decision-making powers, which necessarily involves an assessment of the strength of the evidence against the defendant and the likely defenses. 3, the great width of the DPP's discretion and the polycentric character of the official decision-making in such matters, including policy and public interest considerations, which are not susceptible to judicial review, because it is within neither the constitutional function nor the practical competence of the courts to assess their merits. And other cases are quoted there. Paragraph 18, which sort of sums up this principle, this high test. This court has no jurisdiction to intervene simply because it disagrees with the decision of the DPP, in the sense that if the court itself was exercising the discretion, it would have made a different decision. In order for the court to intervene, leaving aside cases of obvious errors of law, which my learned friend Mr. Taylor is relying on, the decision has to be categorized as perverse, in the sense that no prosecutor would have made the decision that is sought to be impugned in the judicial review proceedings. So the test, milady, that her ladyship must keep at the forefront of her mind at all times when considering this judicial review against the PSC's decision is whether or not it was perverse and whether there was an obvious error of law.
So Mr. Taylor obviously submits,
Yes.
not to overuse the word obvious, but he submits that this is a case involving obvious error of law.
Yes.
The PSC did not have regard to the principles that were enunciated in Salter, whether it cited it or did not cite it. Its reasoning was inconsistent with the approach that was laid out in the Salter decision.
That's right. And I go on to say that my learned friend is not himself applying the principles and law set out in Salter correctly. And that in fact, the PSC has done a good job, and it's not for this court to intervene. The PSC's decision is 22 pages long. It's thorough, carefully considered. As we heard from our learned friend, Mr. Horseman, just now, it took days for them to deliberate. And
But putting all of that aside, how did Mr. Taylor misapply in his submissions the Salter principles?
Yes, well, respectfully, Mr. Taylor is trying to convince or persuade this court that Salter's principles are absolute in its terms, that if someone is found guilty or a finding is made of dishonesty,
Dishonesty.
operational dishonesty, and I'll get to that in a moment,
Mhm.
then they must be dismissed. But even by Mr. Taylor's own submissions, and I've taken a careful note of what he said earlier this morning,
Mhm.
it's clear that the principles in Salter are not absolute. And I say that also in my submissions, in my written submissions, almost invariably, except a very small residual category, almost inevitable outcome, exceptional. All of these terms that are referred to in the various paragraphs that were cited by Mr. Taylor when he was reading out the different paragraphs in Salter, both the lower and higher decision, make it very clear in my respectful submission that it's not an absolute test, but that there are circumstances where a court or a tribunal or the PSC in this case can consider the facts carefully and thoroughly and come to the conclusion that the facts and circumstances of this case, as they have done, fit into that very small residual category where dismissal is not the appropriate result.
So can you, are you going to take me to Salter?
Yes, I can take you to Salter.
Okay.
I mean, all the different parts of Salter that I was going to take her ladyship to,
Mhm.
Mr. Taylor has also taken you to.
Oh, I see.
So we're not, it's a matter of interpretation and ultimately a matter for you, my lady, because all of the different parts of the decision and all of the different parts of the different cases, we're both looking at the same things, really.
I
So
see.
first of all, Mr. Taylor took you to tab 5 of his submissions,
Mhm.
paragraph 20. Well, at 22, it talks about, he talks about the similarities between solicitors and lawyers and police officers. And paragraph 23, 24, it talks about that. Over the page at paragraph, a continuation of paragraph 24,
Mhm.
at little 3, it says cases of proven dishonesty or lack of integrity in an operational environment of which the destruction, suppression, or fabrication of evidence or attempts to do so would be clear examples are the most serious breaches of the code of conduct. In such cases, the sanction of dismissal or requirement to resign would, to use the language of Sir Thomas Bingham in Bolton, almost invariably be appropriate. But there exists a very small residual category where a lesser sanction may be available. And that is what the PSC reasonably decided to do in this case, for the reasons that have been set out in the judgment, as well as the reasons elaborated on by Mr. Horseman in his oral submissions just now. If we go over to the page at paragraph 30 of the same case, I'm just rereading, or I should say, well, at paragraph 29, it just repeats that in noting that in cases of proven dishonesty, the solicitor's disciplinary tribunal had almost invariably struck off the solicitor concerned. The master's
You're reading from paragraph 29?
29.
Oh, paragraph 9 in the same Salter decision.
Halfway down paragraph, yes.
Okay, one minute, let me go back.
Well, maybe I should start at this top of paragraph 29.
Okay, one minute. My paragraph 29 starts, although in bold.
Yes, and I'll start there. Although in Bolt, Underhill J was not considering the police disciplinary structure by comparison with that applicable to solicitors, and indeed none of the authorities appear to have been cited to him, his conclusion that conduct of the sort encountered in that case should normally be thought to merit dismissal sits comfortably with the conclusions of Sir Thomas Bingham, MR in Bolton, in noting that in cases of proven dishonesty, the Solicitors' Disciplinary Tribunal had almost invariably struck off the solicitor concerned. The Master of the Rolls was recognizing that there may be exceptional cases where that sanction could be avoided. The Court of
So is it that you say that the PSC consciously considered this to be within that exception?
Yes, and it's crystal clear in my submission from looking at the 22-page judgment that they understand fully that dismissal is almost an inevitable outcome in such circumstances of gross misconduct. But in the particular circumstances of this case, where the finding of assault was overturned pursuant to grounds 3 and 4 of the appeal, 6 to 9 of the appeal, there were exceptional circumstances that, coupled with the fact that the requirement to have the body cam on was not an operational requirement at that time, and such left them reasonably to come to the decision that there was an exceptional circumstance, that this Pereira matter fell reasonably within the very small residual category. My main point, my lady, is just this, that Mr. Taylor is trying to persuade this court that because he was not dismissed, Salter was not considered or was misapplied. But that just simply is not.
Well, no, I think it's unfair to suggest that Mr. Taylor put it that simplistically. He referred to, for example, I think it was paragraph 56, so somewhere in that region of the decision of the PSC, where they speak about the only harm caused was the reputational. Let me just get the decision in front of me to make the reference where he took me.
Yes, 59. The only harm that could said
Yes.
to be caused was harm to the reputation of the BPS and the undermining of the public confidence in policing, giving an untruthful explanation, and I'll get to that in a moment, in order to protect himself from criticism, does undermine the reputation of the Bermuda Police Service.
So
But it doesn't follow that even if this is found to be the case by the PSC, that they must then dismiss him, because Salter does not say that.
The submission that you have to address is the approach of the PSC to the significance of harm to the reputation of the Bermuda Police Service and the undermining of the public confidence in policing. The approach that the PSC had to those harmful factors appears to be minimized when they use language such as the only harm. That was a submission that Mr. Taylor made. It was not so simply that because they decided not to dismiss him, that there was a conclusion that Salter was not followed, but it was the approach to those damaging factors by using language such as the only harm. I think that was really the thrust of the submission.
Yes, well, my understanding, and I've taken a note, is that throughout Mr. Taylor's submissions, he is trying to persuade this court that it is absolutely, and this is a quote from him, absolutely inescapable that if it's found that Salter was not considered or considered in the case, that he should have properly been dismissed, and that the
On the fact of this case, that was his submission, yes.
And my point strongly is that that is not what Salter says. That's not what Salter says. It's not what Williams says, which follows.
No, but he was making that submission on the facts of the present case, as opposed to a general enunciation of a legal principle.
Yes.
So he was saying that if you take these facts of this case and you apply Salter, it's inescapable that you would that the PSC would have concluded, if using the approach set out in Salter, they would have surely found that dismissal is the only appropriate course.
and my submission is that what this court, with respect, what her ladyship needs to consider and only consider is whether the PSC was reasonable and thorough when it came to its decision to to reverse the finding of dismissal, or the sanction of dismissal for one of a final warning, having taken into account all of the different factors that they clearly do take into account when putting this judgment together. They clearly, I mean, there's 18 pages of considering all the evidence and the grounds of appeal before we even get to any kind of, any kind of conclusion whatsoever. And at page 18, it's very clear in my submission that that whilst they don't actually specifically spell out the case of Salter, and by the way, I represented Mr. Pereira at the appeal itself, we never referred the case of Salter or any cases to Mr. Taylor.
Oh, my lady, I'm sorry. I'm
Yeah.
loath to do this. I must object. That is an entirely inappropriate submission from my learned friend has made. Entirely inappropriate.
Ms. Greening, I think any evidential statements from you have to be disregarded by this court.
Fair enough. Well, my point basically is that there is no requirement for the PSC in its decision to lay out or refer to any cases. And over and above that, in my submission, it's a matter for her ladyship. It's clear, it's crystal clear that the principles set out in Salter and Williams that deal with personal mitigation are considered in this case. And most importantly, the requirement for it to be dishonesty in relation to operational requirements. And it was ventilated and fleshed out in quite a lot of detail in this decision, when they go back and actually quote some of the evidence that confirms that whether or not a body camera is on or off is not an operational requirement at that time. And that is compounded by the fact that his co-accused, Pereira's co-accused, Bowden, did not have his body cam on and was not sanctioned or criticized in any way, shape or form whatsoever. And he wasn't dismissed, he was acquitted. And all of that, and without going into all of the details, what her ladyship really needs to consider is just whether or not the PSC considered all of those things. And it's clear from looking at this thorough and lengthy judgment that the PSC did consider all of these things, and that this court has no right to intervene as a result. They did what they needed to do. They did what was necessary. It was not unreasonable. They have not erred in law. And so this court has no jurisdiction to intervene.
It seems to me that both you and Mr. Taylor are agreed that if I find that there was no obvious error of law and no perversity, then there's really no jurisdiction for me to disturb the decision.
Well, I can only answer for myself, and yes, but my submissions go further than that and say that the test is very high, and that and looking through the lens of the constitutional safeguards that are put in place to protect the PSC's decision-making powers, her ladyship would have to be very, very careful in making any decision to intervene in a decision made by the PSC.
Mm-hmm.
I don't know if Mr. Taylor wants to answer now or reserve.
Yes, Mr. Taylor.
Lady, it's not quite the position. I think there's a conflation of two concepts. We would certainly say that if there's an error of law that you found, that you're entitled to set aside the decision. Something my learned friend said in his submissions, though, goes back to the standard of review of the PSC and the unreasonability of it.
Mhm.
Put another way, if you were to find that the PSC's determination that the sanction of dismissal being unreasonable is wrong, you can similarly overturn the decision. And the reason I say that is because
Wrong because it's unreasonable, or wrong?
so for you to vindicate the PSC's decision, you must find that the sanction of dismissal was unreasonable, because remember, that's
No.
the standard of review pursuant to statute. That's the lens through which they conduct the review. And what I will say now that it's open somewhat, and then I'll just stop. I don't want to interfere with my friend. On two separate occasions, Mr. Horstman said this, that the PSC clearly had in their mind that he could be terminated just for that. And that was in response to the fact that we were no longer dealing with an assault, but just the turning off of the camera willfully and being untruthful about it when he talked about what happened. And what I say to that is, if Mr. Horstman himself on behalf of the PSC has said they had it in their mind that he could be terminated for just that, how is such a termination possibly unreasonable? They're saying we might not have done it, but how can it be unreasonable when he says clearly they had it in their mind that he could be terminated for just that? He said it twice.
And in reply to that, I would say that that's actually very helpful to this court, because it shows that Mr. Horstman and the PSC were considering that carefully, and notwithstanding that, they still found that in the particular circumstances, the exceptional circumstances, Mr. Pereira's case fell within the very small residual category where dismissal was not the appropriate sanction. So again, it wouldn't be proper for this court to intervene in such a decision that is that has clearly been thoroughly considered in such a way. And the exceptional circumstances, as are made clear in my submission in the judgment and also in Mr. Horstman's oral submissions this morning, are crucial, are that Salter is a case very clearly that involves operational dishonesty, whereas this case is not. And that is crucial. If the PSC found that there was no assault by Pereira and Mr. Taylor anticipated that this would come up, then what was Pereira said to have been covering up by not having his body camera switched on?
How are you defining operational dishonesty?
Operational dishonesty is defiance of an operational requirement, and that was dealt with in the evidence and in the judgment when the acting commissioner at that time, Sean Field Lament, gave his evidence, and the body cam expert PC McNabb also gave his evidence. And at page 18 of the judgment, at page 17 of the judgment, the PSC considers this with the heading, was the MPP's finding that the appellant willfully and intentionally turned his body camera off unreasonable? So we can't say that the PSC were not carefully considering and carefully laying out their thought process in this decision. Paragraph 48, the MPP rejected the appellant's explanation that he was not advising PC Bowden to turn his camera off, but rather instructing him to turn his camera on, and he did not intentionally switch his camera off. I just pause at this point to say, all of this turns on Mr. Pereira's account, his testimony at these hearing at the MPP hearing, and whether or not it was accepted or rejected. And that is another point for her ladyship to consider, to distinguish these matters from admissions or findings of operational dishonesty. In the case of Salter, Salter admitted openly that he had told his junior colleague to get rid of a phone following a fatal accident on the road. That is a clear example of operational dishonesty. In this case, we have Mr. Pereira, who testifies and is acquitted at his criminal matter for unlawful wounding. Then he comes to the MPP to the misconduct hearing and testifies, and the MPP reject his account. And the PSC go on to say that they didn't find that to be unreasonable. That is distinct and different from a finding or admission of operational dishonesty within the police force. There are countless examples of officers who testify in courts every day, well, I don't say every day, but not uncommonly in Bermuda, where their accounts are not accepted by the finder of fact. And in my submission, that is in stark contrast to a situation. In fact, I haven't included them, but I have the cases here of examples where police officers have been found, magistrates and judges have said in their judgments that they do not accept the testimony of police officers, and yet they're still working in the service. They're still testifying. Some of them have been promoted, and some of them are very senior members of the police service. That is a different situation altogether from someone being found of dishonesty, impropriety, and operational dishonesty, from someone whose explanation, as it says at paragraph 48, was not accepted. And I ask her ladyship to take that into account when looking at whether or not Salter is even applicable in this case. So at paragraph 48, the MPP rejected the appellant's explanation that he was not advising PC Bowden to turn his camera off, but rather instructing him to turn his camera on. He did not intentionally switch his camera off. In its findings, the MPP dismissed the appellant's account as implausible. The relevant part of the judgment relating to the turning off the body camera is found at paragraph 14G of the MPP's decision. Having heard the appellant and considered his version of events, the MPP rejected the appellant's evidence and made a finding that he intentionally and willfully turned off the camera. And then the PSC goes on to consider, well, now that we've gotten to grips with this part of it, they then see it's noted that PC Bowden's camera, that's the co-accused, was not on during the incident, and he faced no criticism in that regard. And that's clearly been taken into account in deciding what the appropriate sanction is when dealing with Pereira. The matter was considered during PC McNabb's testimony when it was discussed that when PC Bowden alighted out of the car, PC Bowden did not have his camera on. PC McNabb said, in these circumstances, there was no evidence of breach of operational standards when PC Bowden failed to turn his camera on. And then there's a quote that the PSC judgment has decided is important enough to include in their judgment. It's fairly unusual in my submission for judgments to include portions of the evidence, but when they do, it's for good reason. And here it says chair. So that was Mr. Dunch, QC. Assuming it wasn't on PC Bowden's camera.
Where are you reading from now?
Whilst I think you were saying,
Ms. Green,
sorry, I'm just continuing from paragraph 49.
do I have the page cut off? Oh, I see it. Sorry, at the bottom. Yes.
Assuming it wasn't on, quote unquote, paragraph, open paragraph, PC Bowden's camera, whilst I think you were saying, whilst it would have been preferable if it had been turned on, preferable maybe, but not a requirement. You are not surprised, and it is not contrary to operational standards that it wasn't. That's his question. And PC McNabb says that's correct. And then acting Commissioner Sean Field-Levent, one of the members of the MPP, so he was the other one of the panel members. I am working the new policy. It's a real area of new development. Certainly the public expectation now is that the body cameras will be on for every interaction. The culture of what it was to now has completely shifted. And the point of this, milady, is not to prove to you one way or the other the inner workings of the BPS, but rather to show that the PSC considered this carefully when deciding that, yes, he could have been dismissed for that harm alone, but we're now turning our minds to consider whether it was an operational requirement as per Salter. We've looked at the evidence that was put before the panel and given by the panel, it seems, and we can now see the exchange above indicates that it was not against operational standards at the time of the incident to require the body camera to be turned on. The PSC is putting the facts and circumstances of Pereira's case into context, into the legal framework that it's required to do so. In the circumstances of a chase where an officer may not have the time or the wherewithal to turn it on during the course of a pursuit, this was not contrary to operational standards. PC Bowden's situation can be distinguished as he was rushing to the appellant's aid, but certainly PC Bowden faced no criticism for failing to have his camera on during the incident. The comments by acting COP Field-Levent indicated a new policy was at the time of the hearing in the process of being developed, but at the time of the incident, there existed within the BPS a different culture as to the operation of the body cameras. Clearly at paragraph 50, they have, well, paragraph 48 to 50, they have clearly considered what was the requirement by Pereira at that time, and did he breach it? And the reason, the only conclusion that we can come to for why they were going into all of this was to see whether Salter was applicable, whether a breach of operational requirements had been carried out. And they came, and then they go on to say, the MPP found that the appellant had willfully turned his camera off. The PSC cannot say this finding was unreasonable in the circumstances. But notwithstanding that, they've said that it wasn't a breach of operational standards. It's also important, milady, that the PSC considered, and this is in keeping with my submission earlier on about the distinction between an admission or finding of operational, of a breach of operational requirements and an unaccepted testimony from a defendant. They then go on to make it clear that the MPP, sorry, this is at paragraph 52, the MPP, by finding the appellant had willfully turned his camera off, inferred that the appellant was being untruthful in giving his side of the story. And they go, and although my learned friend, Mr. Taylor, has a different interpretation or a different submission to give to the court in relation to this, they go on at the end of this paragraph to say, giving an inaccurate or implausible account in order to shield himself from criticism and potential misconduct charges was, in the PSC's opinion, gross misconduct. So they have come to the conclusion that it was gross misconduct, but it wasn't a breach of operational standards or requirements. They then go on to consider any personal mitigation pursuant to 3410 of the orders, and also pursuant to Salter. Because remember, Salter does not say that personal mitigation cannot be taken into account. What Morris K says is that it can be, but just in a limited fashion. At paragraph 23 of the appeal, of Salter's appeal, K says, as to personal mitigation, just as an unexpected errant solicitor can usually refer to an unblemished past in the esteem of his colleagues, so will a police officer often be able to do so. However, because of the importance of public confidence, the potential of such mitigation is necessarily limited. And that does not say that it cannot be taken into account,
As opposed to.
as my learned friend is trying to persuade this court that Salter says. It says that it can be taken into account, it's just limited. And Williams, the case that's also cited in this bundle by my learned friend, elaborates on that. In fact, I'll go there now. So at tab 8
It was at my,
of my
but I marked it.
learned friend's bundle.
Yep.
At tab 8 is the case of Williams. And I'm relying on paragraph 67.
Let me just pause you for a moment. Ms. Greening, I don't mind continuing through, but I do have to be mindful of staff who are being forced to now work into the lunch hour, and I don't know if they are remunerated for that kind of volunteer time. How much longer are you going to be?
I'm not finished yet.
I don't want to rush you. I just want to have an idea so that I can decide whether we're going to come back or if it's worth a couple minutes.
I think it probably would make best sense to have some sort of break, because that might enable me to gather my thoughts, and I'll be shorter overall if I do that, rather than kind of just going from here to there.
How much longer would you be on a return date?
I think 20 minutes or something like that.
All right,
20 to 30 minutes.
for a half an hour fixture. Give me a moment. Let me just look at the calendar. Actually, I was very helpfully given an indication just now by Ms. Oswood. She said that she is happy to go, and I can give you to 1:30. No, you can finish up, which I think is preferable. Otherwise, I'm going to bring you back. It won't be next week. It will likely be thereafter. It seems to me that it would be better to just finish up. Yeah.
I certainly agree with that, my lady. These things part hurt, especially this far along, are often not ideal.
Yes. So you can have to 1:30, Ms. Greening.
Yes, thank you, my lady. I agree with Mr. Taylor. It's better to try and finish this now for everyone involved.
Good, thank you. I just want to thank Ms. Oswood for that indication. If she can hear me now, thank you.
Yes, I'm very grateful to her also. So I am roughly going through my submissions, and I'm
Williams, if that threw you off.
Yes, but
Okay.
just to help, I am I kind of deviated, but I am still keeping it. So Williams is cited at tab 8 of my learned friends bundle, which is a case that followed Salter in 2016. And I'm looking at paragraph 67, which is on page 18.
Okay.
well, in fairness, maybe I should start at paragraph 66, because this will show in my submission that the PSC did what they were supposed to do and did what was necessary. At 66, in my judgment, the importance of maintaining public confidence in and respect for the police service is constant, regardless of the nature of the gross misconduct under consideration. What may vary will be the extent to which the particular gross misconduct threatens the preservation of such confidence and respect. And the PSC in my submission have considered that carefully. And have not only have considered it, but have laid it out in their judgment for us to see. The more it does so, the less weight can be given to personal mitigation. So then it starts to talk about personal mitigation. Gross misconduct involving dishonesty or lack of integrity will by its very nature be a serious threat, save perhaps in wholly exceptional circumstances. The public could have no confidence in a police force which allowed a convicted fraudster to continue in service, which is not Mr. Pereira. Gross misconduct involving a lack of integrity will often also be a serious threat. Note, it doesn't say always, but other forms of gross misconduct may also pose a serious threat, and breach of any standards may be capable of causing great harm to the public confidence in and respect for the police. So in my submission, this is all still in keeping with the PSC's judgment that, and on that basis, it's not for this court to intervene. Paragraph 67. This does not mean, of course, that personal mitigation is to be ignored. Nothing in the Salter principle suggests it must be ignored. On the contrary, it must always be taken into account. I therefore reject the submission that the effect of the Salter principle is that dismissal will invariably be the sanction wherever gross misconduct is proved. But where the gross misconduct threatens the maintenance of public confidence and respect in the police, as gross misconduct often will, the weight which can be given to personal mitigation will be less than would be the case if there was no such threat, and if the disciplinary body were a court imposing a punishment, whether the circumstances are such that the sanction of dismissal is necessary will be fact-specific decision. Where the facts show dishonesty, case law establishes that dismissal will almost always be necessary, and dismissal will often also be necessary where the misconduct involves a lack of integrity. Where the facts show that one of the other standards has been breached, the appropriate outcome will depend on an assessment of all the circumstances, with proper emphasis being given to the strong public interest in the maintenance of respect and confidence in the police, and consequently less weight be given to personal mitigation. So it makes it very clear there that yes, I think we can all agree gross misconduct, especially when it comes to matters of integrity and dishonesty, are to be taken seriously. But it doesn't say that personal mitigation cannot be considered at all. Mm-hmm. And the PSC, once again, repeating myself, but it's so very important, have taken all of these things into account. They have not reversed the decision, the sanction of dismissal to one of nothing. They've considered it carefully. Mr. Horstman said for days, and they've decided that in all of the circumstances, a final warning is most appropriate in these particular circumstances, in these particular exceptional circumstances. And on that basis, it's not appropriate or proper for this court to intervene in that decision. Particularly,
tell me something, Ms. Greening. What were the restrictions on the appellate role that the PSC had in deciding this after the MPP had disposed of the procedure?
Mr. Horstman helpfully put those, I thought he had put those into the his submissions. At paragraph 3 of Mr. Horstman's submissions, mm-hmm. It is titled Jurisdiction and Powers on Appeal. The jurisdiction and powers on appeal are set out in section 37.2 of the Police Conduct Orders and regulation 28.1D of the Public Service Regulations, 37.2. The only grounds of appeal under this order are that A, the finding or disciplinary action imposed was unreasonable, and that was the one that was focused on. There is evidence, B, there is evidence that could not reasonably have been considered. That's not relevant in this one. C, there was a serious breach of the procedures set out in these orders or other unfairness which could have materially affected the finding or decision. It's little a that the PSC was asked to,
If it was unreasonable.
yes. And that's
And
why so much emphasis in the
where-
decision.
And so where Mr. Taylor emphasizes that Mr. Horstman said that they had it in their mind to uphold the dismissal, can it be said that they at the same time found that to be unreasonable in looking at the decision of the MPP?
Well, it's not just can it be said, they do actually say that they found it to be unreasonable. At paragraph 62 of the judgment,
Mhm.
having considered all of the factors in this case,
Wait a minute.
and
Let me get to it. Hold on, sorry. Paragraph 62.
yes,
Okay.
so I've read out paragraphs, most of paragraphs 50, and then they go in to talk about mitigation. And then at 62, they're concluding, having considered all the factors in this case, and in light of finding no evidence to support the MPP's finding that the appellant unlawfully assaulted Mr. Grant, the PSC finds that dismissing the appellant without notice was unreasonable. The career summary prepared by Sergeant Mello, which referred to the appellant's last performance report, confirms that the appellant has previously displayed a high level of respect for the public and was previously a well-rounded, motivated police officer who had previously carried out his duties in an acceptable manner and was an asset to the Bermuda Police Service. He has no previous warnings on his personal record. So they're considering all of the factors in the case, and we've gone through all of those. And in light, and they specifically lay out one of them, which is that the finding that no evidence, there was no evidence to support the finding that there was an unlawful assault by Pereira. They found it to be unreasonable. So at that stage, they found it to be unreasonable. Over and above that, as would take place in an exercise by a judge in a criminal court, similar, they then go on to look at any mitigation in relation to the offender himself, not the circumstances of the case. 63 says, the PSC does, however, consider that the appellant's conduct was serious. So it's not like they're ever ignoring that fact. However, taking into account his past record of service and having found the penalty of dismissal without notice was unreasonable for the reasons given, no breach of operational requirements, no finding of assault, looking at what happened with Bowden as compared to what happened with Pereira, it has decided to vary the disciplinary act of dismissal without notice and in its place impose a final written warning. This is a very, very thorough and carefully written judgment, more so than many judgments in other forums. And it's not for this court to intervene in a decision that is as thorough and taking into account all the different principles of law. Thank you. Sorry, I'm in quarantine, so I'm having people deliver food to me.
Ms. Greening, I think we all know what the reality is. That's fine.
Sorry. So that was Williams and the rest of the judgment. At paragraph 14 of my submissions, I conclude that there is nothing perverse about the PSC's decision, and I add also that there was no error of law. It cannot be said that no panel properly directing itself could have come to that decision. Paragraph 15. In reply to the applicant's submission that Pereira cannot be reinstated because of the insuperable difficulties that will now attach to any deployment of PC Pereira in the evidential chain, given the need for him to disclose the disciplinary findings of dishonesty, that's the quote from his submission, Pereira was not convicted by a court of dishonesty. The PSC found that they could not accept certain portions of his testimony, and I've already sort of presented my submissions in relation to that. That does not make him a convicted liar or dishonest. Any tribunal of fact has the right to accept or reject all or parts of an individual's testimony. This is the process of weighing the evidence and coming to a conclusion, having considered the evidence and deciding the appropriate consequences as a result. And I've already stated, there are examples of serving officers that have actually found to have lied and acted dishonestly in and out of the courtroom and continue to serve as officers. One that comes to mind is Police Constable Colin Mill, and the judgment in that
Lady,
case,
I'm sorry, we're
well,
we're receiving evidence. It's not.
Well, wait a minute. If she's going to refer to a judgment and we're not receiving evidence, are you referring to another judgment?
I haven't submitted it as part of my authorities, so I don't know whether I can refer to it or not. But
no authority that you, well, if it's an authority you can refer to it, you can send it in, and if any supplemental submission arises out of it, then, but by the Supreme Court or by
it's the well-known case of Kamisi Tukumbo.
Yes.
In the magistrate's court, when an acting magistrate came from, I think, Canada to preside in that matter,
Yes.
and it was found that PC Mill, and I quote, and I will hand this in, I have concluded that PC Mill is not a credible witness. As a witness, he was unresponsive, evasive, self-contradictory, and disingenuous. He goes on to say that he has.
So the evidential part would be the fact that he's still an officer employed in the Bermuda Police Service.
He is, and the crux of this case is.
Was there any disciplinary Were there any disciplinary proceedings that came out of that judgment?
None.
Okay, so what do you want me to do with it? I mean,
my point is that for my learned friend to be saying that the only outcome in relation to this matter where Pereira has testified and his testimony has not been accepted is dismissal. It's inconsistent when there are other officers.
You can't rebut it with that, Ms. Greening, because unless you can refer me to some sort of judicial reasoning, quasi-judicial reasoning that deals with the conduct, then it doesn't assist me that you.
Yeah, I understand what her ladyship is saying. Nothing happened in respect of PC Mill.
So it's of no value to these proceedings. I mean, I can understand your temptation to refer to it, but it really does not assist. Now, if, for example, the comments that were made by the acting magistrate led to disciplinary proceedings and there was a reasoned judgment as to why it is that he was not dismissed, then obviously I might be interested in that in that kind of reasoning, especially if it were to be a judicial decision. But otherwise, I mean, they're really not helpful observations to make.
The only other case that does deal with an officer who was found to be dishonest and nothing happened to them either was the case of Emerson Carrington of 2016, where he was found to give the heads up to his girlfriend or someone he was in a relationship with as to the police coming to her house to search it. And the outcome of that was, well, nothing. And I can hand both of those cases up for the court's consideration. As you said, the first one is probably not going to be of much use to this court, given that nothing has happened. But I know I'm going to deal with it shortly. In relation to our judicial review, just in closing, in relation to our judicial review that was filed before the Commissioner's judicial review against the PSC, we claim that Mr. Pereira was dismissed unlawfully before due process was complete. He was dismissed immediately after the MPP's finding on the 20th of January 2020, when the BPS knew that he had a right to appeal. He did in fact exercise that right to appeal, and his appeal was upheld. So he has not been reinstated despite numerous requests to be so. He has not received any back pay or benefits since the 20th of January 2020. And in our submission, that is not lawful or right. And he is entitled to immediate either reinstatement or back pay pending the outcome of this judicial review. He has been...
If I were to find in favor of the police commissioner, would I still need to address my mind to any sort of interim relief that your client would have been entitled to between the time that the PCC ruled in his favor and any decision out of this court?
Well, I think it would be difficult for me to argue that, because it's the flip side of the argument that I'm making, that due process is not complete. And in the same way that the commissioner had a right to judicially review, well, although I don't agree with it, he had the right to judicially review the PSC as a final remedy, as he has done so now. You know, we also had the right, my client also had the right to have his due process completed, which he wasn't afforded. So the answer to your question, I think, in fairness to everyone, has got to be no.
Okay.
But
obviously, if I rule now in favor of your application, then you would obviously strongly contend that some order of this court would have to address the rights that he would have had from the time that PSC decided against his dismissal. From
the date that they unlawfully dismissed him on the 20th of January, and any damages that flow as a result of being denied those rights, benefits, and remuneration until due process was complete. And at this stage, it's probably worth also reminding the court that whilst I accept that the applicant in law had 6 months to file a judicial review, our client waited 3.5 months from the 17th of August until the middle of December for the judicial review to actually be filed, whilst waiting in Bermuda, having to sell his personal effects right down to his jewelry in order to survive here, waiting for due process to complete, and he still waits for that day to come.
I mean, it was open to your client to file an application for judicial review sooner than the application which was filed, wasn't it?
Well, we found it fair. Yes, I see what you mean. Well, we waited until the outcome of the PSC's decision, because if we hadn't been successful in the PSC's decision, which we were, but it hasn't benefited him at all at this stage, then the judicial review would have been defunctus. But we waited until the outcome of that. We were fairly confident that we would be successful, at least in some of the grounds, which we were, and then we filed the judicial review pretty soon.
I mean, the decision is dated the 17th of August, 2020.
Yes.
And your application for leave,
yes,
was filed on what date?
I don't have it in front of me. I'm sure that my client will know the answer.
Well, it's on a court file. I can find it. I mean, I can see that your notice of originating motion
Actually, maybe I do have it.
was filed until the 13th of January 2001, but it's a question as to when you got leave. And that looks.
Lady, if I may assist, it looks like the filing took place for my documents on the 21st of October.
Yes.
Okay.
Lady, you'll remember, I don't remember the details. You'll remember there was some sort of unusual summons that was filed in
remember it.
advance of that.
I remember it, yes.
So I think there was a procedural misstep of some sort. I
There
don't
was,
recall the details.
Yes, well, it wasn't.
Without,
There was a summons filed, one moment, there was a summons filed outside of the application for judicial review process. And the both of you appeared before me in a Thursday chamber session. It was not an originating document. So I expressed some concern as to whether or not the matter was properly before me and found that it was not. When I had the benefit of a summary description from you as to what this was about, I suggested that it seemed to me the more appropriate course was to file an application for leave for judicial review. And I think it was even then that I came to understand that there would be cross applications filed in any event. That precedes the 21st of October 2020 notice of application, but all of this is in the context, obviously, of your complaint, Ms. Greening, that your client has waited for an extended period of time in respect of the judicial review proceedings. But I just note that your notice of application was not filed until the 21st of October 2020. And the decision of the PSC was dated the 17th of August 2020. I presume that you would have received it very soon thereafter.
Yes, but remember, you're late. Remember also, filing a judicial review application is a last resort. And between the 18th of, between the very next working day after the PSC's decision came out and the date that the application for, well, the summons, that was the incorrect way of filing for the same relief, was filed, both myself and my client wrote relentlessly to Human Resource Department, the Accountant General, and to the BPS asking
Let me stop
if they
you
were
there. It's obvious to me that if I were to decide in your favor, I would have to hear from the parties as to
Yes.
what the appropriate relief is
Yes.
that comes from that. I would not make that decision at this stage. I think the only thing I need to concern myself with at this point is whether or not the application in principle fails or succeeds.
Yes. Yes, and on that note, we submit that the commissioner's application for judicial review against the PSC and with us as interested parties must be dismissed by this court for all of the reasons, the legal reasons and other reasons that have been given and presented to this court, and that the decision of the PSC, which was proper, thorough, and they did what was necessary, be confirmed by this court.
Mhm.
And if it is that the court decides rules in our favor, then we will be asking for a separate hearing to deal with the issue of damages and the like and costs.
All right.
you.
Mr. Taylor, is there any remark you wanted to make before we finish? I'm very concerned about obviously how late the time is, but
My lady, I would ordinarily reply. Maybe I'll just remind you a couple things.
mhm,
We said it in the stay application. The constitutional point my learned friend raised is completely misguided. There are any number of judicial reviews of the Public Service Commission in this jurisdiction that, my lady, you could find, any of us could find.
mhm,
None of them apply this constitutional standard. The reason they don't is because the decision of someone like the Director of Public Prosecutions, as the case says, is discretionary. And a number of the PSC decisions are discretionary. For example, I'll refer you to the case of Mr. Parent Chief that you and I will know, where Mr. Parent Chief sought review on the basis that he was a qualified Bermudian
Yeah.
to fill that role. and it was given to a non-Bermudian. If there's no discussion in any of the cases, you would be, excuse the colloquial, sticking your judicial neck out to apply a constitutional standard to a quasi-judicial body making a determination. Even if you're not with us, you saw in the decision, the Chief Justice went on to say there's an exception for obvious mistakes of law, which we say this is. Even so, if you apply a perverse standard, this is perverse because of the mistakes that were made. I've never said Salter was absolute, and I apologize to my learned friend for perhaps not being clear in my submissions. Salter says what it says, as does Williams. What I'm saying is that, as you lady said, in the context of this case, there is an inevitability of the result, we say. I want to address you really very quickly as well on operational dishonesty. Operational dishonesty is not limited to whether a policy about a particular operation is in place or not. You remember I took you in Salter to questions about destruction or suppression of evidence. This was a suppression of evidence case. It was willfully done. It was operationally dishonest. And the fact that there wasn't an express policy about body-worn cameras is completely and utterly irrelevant.
Yes.
Milady, you asked my learned friend about what Mr. Horseman said in his submissions about, clearly it was in their contemplation that he could be dismissed for just those two aspects, namely turning off the camera and not telling the truth about it. And the very fact that he's indicated that was in the contemplation of the PSC means that it couldn't have been unreasonable.
He not said that as a matter of evidence. He said it as an analysis.
Well, that's correct. But I mean, I suppose, again, getting to the unreasonable standard, you know, it's not unreasonable in these circumstances to decide the sanction of dismissal is appropriate. And again, on Salter, there's this, we considered Salter. Lady, I remind you, it's not mentioned. The other thing that is, I think we submit should be clear on whether Salter was considered or not. I refer you back to my learned friend, Mr. Horseman's submissions. The fact that he felt the need to go into a fairly elaborate analysis of exceptional circumstances in his skeleton argument now makes it very clear that they weren't considered at the time. There's nothing in that decision that deals with exceptional circumstances, and they never asked themselves the right question. So reverse engineering now doesn't work. It just doesn't. That's everything, my lady, from me, unless you have anything further.
Thank you. I just want to comment that I've had very impressive submissions from both you, Mr. Taylor, and from you, Ms. Greening. I'm very grateful for that. It will be of much assistance to me when I come to deliver a decision, which will be in writing, and so I do reserve. The ordinary time frame, as you know, 6 weeks before judgment, will likely be handed down. If I'm going to be any longer than that, you will get some communication from the registry as to how much longer you should wait, but I am hopeful that I can deliver a decision to you in draft in the first instance within that time frame.
Very much obliged, Committee.
Okay.
Thank you.
So unless there's anything further, I will adjourn and judgment is reserved.
Thank you, my lady.
Thank you.